I will begin by having the division perform a roll call.
Daisy Glassburn,
Here.
Clint Taylor,
Here.
Darius Wise,
Here.
Brent Goff.
Here.
Rob Stylo is missing today, so there is your quorum.
All right, we have two prior meetings to approve minutes for. Can I have a motion to approve the board meeting minutes for March 6th, 2025?
I'll make a motion.
I'll
I have a
second.
motion. Who is that?
This is Brent.
Okay, great, Brett. I have a motion and a second to approve the meeting minutes for March 6th, 2025. Is there any discussion? There's been a motion and a second to approve the meeting minutes for March 6th, 2025 of the Board of Real Estate Appraisers. All in favor, say aye.
Aye.
Aye. Those opposed, say no. The motion passes. Next, we need approval of the meeting minutes for April 3rd. Can I have a motion to approve the board meeting minutes for April 3rd, 2025?
This is Clint Taylor. I approve.
You're making the motion?
Yes, please. Sorry.
I have a motion. Do I have a second?
I'll second.
There's been a motion and a second to approve the meeting minutes for April 3rd, 2025. Is there any discussion? Alrighty, there's been a motion and a second to approve the meeting minutes for the Board of Real Estate Appraisers for April 3rd, 2025. Excuse me. All those in favor say aye.
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 All those opposed say no. And the motion passes. Next, we have policy matters. Marcia or Garrett, did you want to?
So I will be taking over policy matters. The first item on your agenda is a discussion about roles and responsibilities of the board, the division, and the attorney general. And this is just so that you guys are informed of kind of what everybody does. So first off, the Board of Real Estate Appraisers is the type 1 board, which means you guys are policy making. Your role is to approve or deny license applications, investigate complaints, make disciplinary decisions, and also develop policy, which you do through rulemaking, although we don't do that very often. The role of the division is to basically assist you with your functions, but we are not the decision maker for you. Although you have issued a delegation of authority that allows us to do some of your work on your behalf. So like with license applications, if there doesn't appear to be a deficiency in their education and their experience, their examination, they don't have a criminal background, we will issue licenses on your behalf. That ensures that practitioners can get licensed and go out and practice faster than if you wanted to review all of the applications yourself. We review the complaints that come in to basically determine whether the board has jurisdiction over the subject matter of the complaint. Then they are assigned for investigation. We then bring most of those to you for consideration. If it looks like an issue that you do not have any jurisdiction over, or there's no evidence of a license law violation, we usually handle those at the staff level. But if there does appear to be evidence to substantiate a practice violation, we bring those to you for you to make a decision on whether you're going to discipline somebody, and if you are, what type of discipline you want to impose. And then with rulemaking, most of the time with this board, what you see come up are just rules pertaining to changes in the AQB criteria, updates made to USPAP so that we can adopt the current version of the standards. And occasionally we will go through and do a full-blown rule review of all of your rules to make sure that they are timely and pertinent. And if they aren't, that's when we ask you to not adopt a rule, and we will ask you to repeal them so that they go away and we don't have practitioners trying to comply with regulations that are really kind of antiquated or don't really apply to the industry. But on your behalf, the division will draft those rules for you. In some instances, the boards or commission will give us direction on what they want to see in a regulation. We draft that. We do the filings with the Secretary of State. The rules are presented to you for adoption, however, and if you choose not to adopt something, then it doesn't become a rule. Another aspect of what the division does is, so the division is charged with managing resources. So if there's a budget issue where a program is underfunded, I have to manage that at the division level. I can't spend money that the division doesn't have. So if we encounter a budget shortfall for a program, I have to figure out a way to manage what resources we have and prioritize basically your work based on that. Fortunately, Board of Real Estate Appraisers that's not been an issue for a long time, and hopefully it won't become an issue. But that is one of the things that can kind of cause our two paths to diverge. You guys may be wanting to do one thing, but if we don't have the resources to do it, we're kind of at a stalemate, and it's not going to happen just because we can't spend money that we don't have. There's criminal implications with that. And as much as I enjoy you guys, I'm not going to jail for any of our boards or commissions. And so you've got licensing staff that manages your applications. You have 2 investigators that deal with your complaint investigations, and they also do your experience reviews. We have an expedited settlement program, which is Penny Elder and Michael Turner. They try to get your cases resolved, and if we can't get your cases resolved, then the Attorney General's office, that's primarily one of the functions that they perform for you all, is litigating your cases. But that's not the only role that they perform. If you are looking at adopting a rule or setting a policy, the Attorney General's office will weigh in on that. They'll provide you legal advice. They will also basically evaluate whether the regulation that you want to adopt is permissible as far as state statutes, federal regulations within your authority. I'll give you a good example of something that happened in another state that's this is one of those times where we would want the AG's office to weigh in. So I don't know if you guys have heard about it. It's been probably 15 years since this case happened. It was the North Carolina Board of Dental Examiners. They had decided that they were going to require people to do, I think, teeth whitening to have a license under them. This ended up going to the Department of Justice, or the Federal Trade Commission, I believe, at one point, who ruled that that was outside of the scope of their authority. So say you decided that you wanted to expand your authority over people that do personal property appraisals, and you were going to require them to have an appraiser's license to do that. That is when we would hope that the AG's office would weigh in and say, whoa, that is not within the limitations of the Practice Act or within the board's authority. You can't do that. I mean, ultimately, the board could decide to go against legal advice given by the Attorney General's office. That's usually not advisable. Doesn't set you guys up for success. But part of their role at the AG's office, whether it's a disciplinary case or a policy matter, is they are here to advise you about what you can or cannot do. If you told them that you wanted to adopt a rule that required appraisers to wear a blue shirt on every Wednesday, then the AG's office would advise you whether that is within your jurisdiction as a regulatory body. They would also present you with risks of adopting that sort of regulation. So they're really here just to provide you with legal advice and to make sure that whatever decisions you make can be supported within the limitations of the law. So with that, I also want to let you know, as the decision makers, we offer you recommendations, and the AG's office also offers you recommendations on how to either promulgate your rules or also disciplinary matters. They're just recommendations, and you don't have to go along with them. While we may not agree with your decision, doesn't matter. You guys are the decision makers. So like if you are reviewing a complaint investigation today and you don't agree with staff's recommendation, you can go and do something completely different. You may find that there was nothing wrong and choose to dismiss the case. That's fully within your purview and your rights as a board. Now, we may ask you questions just so that we have for future reference, kind of, if you can enlighten us why you don't think something was a violation of the license law, why you don't want to go a certain way. We may ask you questions. Please don't take offense to that. We are just seeking some guidance so that if we see future cases where it's got similar circumstances, we're going to rely on your decisions in those future cases of how we make our recommendations. We want to make sure that the decisions that you make are not considered to be arbitrary and capricious. And we also try to make sure that discipline is managed in a equitable and consistent manner. Now, several of you on this board, it's a 7-member board. There are, I believe, 4 of you off the top of my head that hold credentials. Just because you disagree with us doesn't mean that we're going to suddenly open a complaint against you. That's not what's going to happen at all. With that said, though, you are not above the law. So if you are out there practicing and say, like, tomorrow, one of you decides, you know what, I'm not going to do all of the analysis anymore. I'm just going to appraise the contract price from now on. Okay, well, that's a violation of the license law. And if somebody files a complaint against you, we're going to review that, and it's going to appear to be within the board's jurisdiction, and we are going to then conduct an investigation. And if the claims appear to be substantiated, that's when we're also going to be having a discussion with the AG's office about how to present the matter to the board and deal with it. And ultimately, that could result in a conversation with the governor's office if we have a board member that is actively violating the practice standard. I cannot think of a time that has happened with this board. There have been other things that have come up over the years, again, not necessarily with this board, with other ones that we've had, where board members or commission members have made statements that are not a good reflection of, like, public service, would reflect negatively on the board, the division, the department, and ultimately the governor. And when those types of things happen, then you usually will get a phone call from me to discuss it. And this is after I've had a conversation with boards and commissions as well. Just keep that in mind. But you should not feel free to voice your opinions about the issues that are within your jurisdiction, for fear of any sort of retribution from the division staff or from the Attorney General's office. I think it's really important during these meetings that you do discuss the matters, because it's not only helpful for division staff and also the Attorney General's office, it's helpful for the licensees as well. A lot of them will listen into your discussions about different practice matters, and that kind of serves as guidance for what they are doing out in the industry when they are practicing as well. So do you have any questions for me about that?
I have a couple. When you do the rules, overall, all the rule review, is that initiated by you all? Is it on a schedule, or how does that begin?
So state law has set a particular schedule, but in keeping with that, you also have to look as far as when a sunset review has occurred, because you're not going to do a rule review the year of the sunset review or the following year of the sunset review. I believe you guys are probably next up for a rule review. I have to double check. But they are initiated at the division level, and it's so that we can comply with state statute.
And could the board initiate a clarification for a particular rule, or relook at it outside of that protocol?
Absolutely. So if you think one of your regulations is problematic, it's out of date, it needs updating, it needs to be repealed, that is definitely something that you can bring to us, and that would kind of fall under item B on your agenda when we ask for agenda items on the next board meeting. That's a good time to offer those up. You can also send me an email that you want something on the agenda, and I'll put it on your meeting agenda for discussion.
Okay, awesome. As far as similar to the real estate commission, are we able to issue position statements similar to that or no? As a board?
I think the board has been kind of hesitant to issue position statements just because of the massive amount of advisory opinions and statements in USPAP itself. But occasionally the board has issued something similar to a position statement. Like at one point, I want to say it was like in 2012, we issued an advisory just based on like real estate appraisers are not property inspectors. I think part of that had to do with the whole issue with carbon monoxide alarms and appraisers being tasked with basically going in and verifying whether alarms were functioning and that sort of stuff. So the board had issued an advisory on just that you are not the same as a property inspector. So if you're seeing
And an
something,
advisory is just, oh, sorry, go ahead.
if you're seeing something that you think an advisory would be helpful on, that's definitely something that the board can discuss and give us direction on what you want to do.
And an advisory is different than a position statement.
Only by title.
Right.
So if you want to
Okay.
call them position statements, you can. The important thing to keep in mind, so the Real Estate Commission has position statements and they have quite a few of them. Those
Right.
are strictly guidance. They do not carry the same weight as a regulation or a law. And so when the Real Estate Commission is looking at a broker that has violated the Practice Act, you will hear them say that they violated a certain statute or a rule. You will never hear the Real Estate Commission find that somebody has violated a position statement, because you can't violate a position statement. They are strictly guidance. And a lot of the
Okay.
time it's kind of best practices.
I'm sorry, I didn't hear the last part. What'd you say?
A lot of the time it's kind of best practices that they're hoping to convey in the position statements.
Okay. Um, did anybody else have any questions on that? Alrighty. We can, I suppose, Marcia, the next one is adding stuff to the agenda.
So is there anything that you would like to be placed on your July agenda?
I would like to go through and have some discussion surrounding Rule 11.3, the wording in that, and just in general, the clarity.
Okay. We will put that on your agenda. Anything else?
Marcia, this is Brent Goff. I don't remember what rule would apply. I'm sure you could help with that, but the two investigators, I'd like for them to be able to interview complainants. We had an instance where
Brett, I can't hear you very well. Is that just on my end or?
it's probably me. I'll try to speak up. Can you hear me better?
Yeah, it's
Yeah,
a
a little
little bit
bit.
better now.
Okay. So, Marcia, I don't remember what rule would apply, but we had an instance recently where one of the complainants just didn't want to finish up with an interview with one of our investigators. And I'm wondering if we could look at the rule that requires a licensee to provide information, and does it say that they need to submit to an interview in the rules?
So in the rules, they are not required to submit to an interview. They are required to provide a response and then any requested documents. But the interview itself, they are not mandated to comply with. And this is so I will definitely put this on your agenda for July, because I think this is a time where you're going to hear some advice from the Attorney General's office.
Okay.
Particularly, I mean, we have subpoena authority, so you can subpoena somebody and require them to kind of submit through submit to an interview that way. It's a subpoena for testimony. We don't do that too often. When you're dealing with a complainant, though, I think one of the challenges is somebody may be like, they may be at the point where they submit that complaint, but then for whatever reason, they may not choose to participate in the investigation. And that's just something that through the investigative process that we have to kind of work through. But I will put this on your agenda for the July meeting. And then that way, Zach can also kind of provide you with some advice. I mean,
Yeah, maybe I misspoke. It wasn't on my mind for the complainant to submit to the interview. It would be
the respondent.
Right, yeah, that's what I was thinking, that I want the investigators to be able to do their job
Okay.
and get to the truth. And if the licensee just says, I don't want to play, I don't want to talk with you, then let's look at the rules on that.
Okay. And so I've got that on your agenda. So we'll do rule 11.3, and then also a topic of requiring respondent interviews. Anything else, board members, for the July agenda? Okay.
Actually, you know what, Martha? I don't know if this would be an agenda item, but I know there's a statute requirement for board members. I would just like to see a full board at some point, but what
I
the
think we all do.
requirements.
So there's the two vacancies on your board. One is for a member of the public. So with a member of the public, we are looking for somebody that does not possess a professional license regulated by the Division of Real Estate. So we don't want a real estate broker, an appraiser, it can't be an appraiser, and we don't want a mortgage loan originator. And then the other seat on the board is for an appraiser with eminent domain experience. So with licensees, they are also making sure that one of the things that's evaluated is like, have you had prior complaints in front of the board? Have those resulted in any form of remedial or disciplinary action? So that is something to keep in mind with the practitioner seats on the board. And in general, typically when the governor's office is looking at making appointments, they want to make sure that the composition of the board is representative of the composition of the state. So they look for diversity in board members as well. And one of the challenges with the appraisal board is that 98% of, I think statistically, 98% of the appraiser population is Caucasian, male more so than female. So when they're looking at composition of the board itself and the demographics of the citizens of Colorado in general, they are looking to make sure that there is more diversity than like 98% Caucasian.
Where the eminent domain element seems, I guess, where does that come from, and what is
It's in
the logic?
statute. And
Yeah.
So it is not something that the board deals with very often. It's possible that at your next sunset review that is a seat that may be evaluated at some point, just based on the fact that you don't have a whole lot of eminent domain complaints that come up. But that's statute language that requires an appraiser to have that type of experience for that seat on the board. The past couple people that have served in that spot have worked for CDOT in the past, but that is not a requirement. So it's not like it's a CDOT position on the board. It's somebody with eminent domain experience.
Marcia, from a recruitment standpoint, how are we recruiting for those two roles? Is that open to the board to help recruit? Are you looking for the board to help recruit? Who's responsible for that?
Well, the governor's office makes the appointments. I reached out last week to try to get like just some suggestions on where I can start cold calling. I have tried this before. I've reached out to the Chamber of Commerce's in various different non-metro municipalities. That didn't come to fruition. So the past few weeks have been a little challenging due to another issue that I'm dealing with at the division, but I'm going to start cold calling next week. But if you guys have people that you think would be a good fit for the board and meets one of those two criterias for the board seats, please send them my way.
That's helpful.
Yeah, that eminent domain aspect, when I've talked to people, that's the tough one to
Well,
find.
what makes it also tough is not only having that experience, but also like the whole past board complaint, possible remedial action or discipline.
Right, yeah.
It further narrows the pool.
Marcia, I think I can help in some of that. I have some seasoned appraisers that have been doing it for 30 plus years that have experience cert gen roles and stuff like that. So I can throw a couple names your way that I think could potentially fill the appraiser seat and have the experience in the eminent domain. Luckily for me, I've had to deal with that recently on a few reports. So it might be kind of serendipity there.
I welcome any assistance that you can give me in getting those spots filled.
Absolutely. I'll see what I can do.
Okay, so I think we've covered policy matters A and B. I will turn it back over to Chair Glassburn for citizen participation period.
Alrighty, thanks, Marcia. We'll go to the citizen participation period. Anyone can bring their concerns about matters not on the agenda before the board. You're just asked to keep your remarks to about 2 minutes. David, I don't know if we have anybody.
Thank you, Chair Glassburn. Anyone from the public that would like to speak to the board, there is a raise hand icon in your Zoom toolbar. Please feel free to click that and we can go ahead and unmute you. Let's just give it a moment, chair members, and then we'll see if anyone does that. Seeing none, I'll pass it back to you, Chair.
Alrighty, we will move to complaint matters. Let's see, Marcia.
And I'll be presenting the complaint matters.
Sorry about that, Gary.
No problem. This first board matter A is complaint number 2025110. The complainant alleged the respondent did not adequately analyze the market conditions, failed to select a single comparable sale within the defined neighborhood boundaries, and failed to properly support adjustments. Additionally, the cost approach did not appear to have been properly developed and supported. In reviewing the report and work file, there appeared to have been potential USPAP violations of the scope of work rule, ethics rule, record keeping rule, and multiple violations of standard rules 1 and 2, as well as board rules and state statutes. The respondent appeared to have inadequately researched, analyzed, and documented the neighborhood market area and the current market conditions. The report did not contain the specific criteria used to determine comparable properties, nor was there sufficient commentary concerning the selection of the comparable sales. There was insufficient commentary or documented support for the adjustments in the sales comparison approach. And in the cost approach, there was no analysis provided for the site value, and the data sources for the replacement costs were inconsistent and unsupported. Finally, there were insufficient summaries of analysis to support the opinions and conclusions made in the report. Possible violations include 1210-613-1B, 1210-613-1G, the ethics rule, scope of work rule, record keeping rule, as well as standard rules 1 and 2. Recommendations include diversion, a work product review of 6 appraisals within 3 months, and coursework in residential sales comparison and income approaches, residential appraisal site valuation and cost approach, residential report writing and case studies, and reliable record keeping, as well as a fine of $1,000. And Investigator Walker is here to answer your questions.
Let's see. Do I have a motion to accept staff's recommendation?
I have a question on the investigative report.
Go ahead, Brent.
Okay, the report lists previous board action in 2015. Is this, does this recent complaint show a pattern? Are we seeing a pattern here? And if so, is that why the fine is now $1,000 recommendation?
Well, the most recent complaint from 2015 had to do with a non-compliance of continuing education. However, there was another one back in 2008 that had to do with some ethical violations. Particularly, it was he had affixed another appraiser signature without their permission. So
I see that. Okay. Thank you, Rob.
Anyone else have any questions for Rob? If not, can I get a motion to accept the staff's recommendation?
This is
I'll
Brent.
make the motion. This is Daisy. I'll make the motion. Do I have a second?
This is Brent Goff. I'll second it.
Okay, I have a motion and a second. All those in favor say aye.
Aye.
I
Aye. All those opposed say no. The motion passes. Let's see, the next complaint is 2024-2026.
That's right. And this is complaint matter B. And in this complaint, the complainant alleged the respondent's search criteria for his comparable sales in his appraisal report utilized price as part of his search basic criteria. The appraisal report activity lists the comparable search parameters in the addendum of the report. The search criteria listed price from $410,000 to $470,000. While selecting comparable properties based on price may inadvertently favor properties within a predetermined price range, it appears that additional search criteria was included that adequately reflects comparability rather than focusing on price. The support and sales comparison approach to value seems to be simply stated. The respondent referred many times to a paired sales analysis whose methodology is not depicted in a way that the intended user could interpret or even understand. Possible violations include 12.613.1G, scope of work rule, record keeping rule, as well as standard rules 1 and 2. Our recommendation in this matter is to refer it directly to the AG's office, as you had previously reviewed matters involving this respondent before that have been sent over there.
Let's see. Do I have a motion to accept the staff's recommendation on this?
Ms. Darius, I'll make the motion.
I have a motion. Do I have a second?
This is Clint Taylor. I'll second.
Okay, I have a motion and a second. Is there any discussion over the matter?
This is Brent Goff. Mr. Lyle, can you talk about the timing of this matter versus the matter we previously discussed?
The previous matter regarding the same respondent,
Yes.
I can look that up for you. I don't have that information right in front of me. Investigator Wentz, do you happen to have that information?
Yes, are you referring to 2024-430, which is the stipulation for diversion? There was a stipulation for diversion, and I believe that the actual board is actually voted to actually revoke his license.
Okay.
Yeah. Hey, Brian, it's Zach. Are you asking about the timeline before this meeting, or are you asking about the timeline going forward?
Before the meeting.
Okay, yeah. You voted at the special April meeting for revocation.
And that I delete and destroy all that information. I just wanted a refresher. And going forward, if we refer it to the AG, what happens after that?
It'll just proceed like a normal case. The notice of charges hadn't been filed yet because of this complaint, and so we'll just combine the two and get it filed shortly.
Okay, thank you.
Thank you.
So they're two separate things, but just because of the same respondent, you just lump them together in terms of, is it become one case or no?
Yeah, it becomes one case because it's when two parties have multiple matters between them, you can combine them into one case. That's totally fine.
Okay. Anyone else? Alrighty. I have a motion to accept the staff recommendations for complaint 2024-2026. And I have a second. All those in favor say aye.
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 Aye. Those opposed say no. The motion passes. Let's see. Doesn't look like we have licensing matters or ESP. Unless there's anything else, we can adjourn the meeting. Does anybody have anything else?
No.
Okay, can I get a motion to adjourn the meeting?
This is Brent Goff. I make a motion that we end the meeting.
I have a motion. Do I have a second?
Darius Wise, I'll second.
Alrighty, I have a motion and a second. All those in favor say aye.
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 Aye. All those opposed? No. Alrighty, the meeting is adjourned. Next one's July 10th.
Thanks, guys.
Thank you so much.
Terrific. Take care, guys.
Thanks, guys.